how to avoid the first-headed monster probate court. Oh, hey, folks, Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question was, hey, Patrick, what's the difference between a will versus a trust? And folks, this is the age-old question. And the big takeaway, folks, please know your will is your admission ticket to probate court. I'm going to repeat that. Your will is your admission ticket to probate court. Folks, because a will does not avoid probate court. A will is going to put all your affairs in probate court. A will, folks, sadly, unfortunately, is typically woefully insufficient to properly protect your hard-earned assets and your loved ones from the metaphorical four-headed monster. Probate court is the first one, or the tax man, or financial creditors and predators. And a will certainly is not going to protect your hard-earned assets from the nursing home. So, folks, very common misconception, will's going to end up in the dreaded ugly milk crate. So, folks, how do you slay the four-headed beast? You need to create a trust or a treasure chest in step one, right? But not just any old trust, folks. Even a trust will end up in probate court if you do not engage in step two, which is critically important because that's where the rubber meets the road. That's where all the magic happens, folks. Step two is the process of trust funding or asset retitling, getting all your treasures titled to your trust, right? If you've got a home, make sure your experienced elder law attorney retitles your home from Bill and Mary as individuals to Bill and Mary as trustees, or to Bill and Mary's child as trustee of the Family Medicaid Asset Protection Trust, and retitle that trust, record that deed at the County Registry of Deeds office. Do the same thing for your non-real estate assets as well, folks, and make sure you work with an experienced elder law attorney that knows the rules of engagement around how to properly fund your trust. Because the old saying, folks, sadly, people die, but trusts do not. Trusts do not, folks. So long as they're funded properly, your funded trust, not just any old trust, because most, from my experience, are not funded. They have to be funded with your treasures during your lifetime. So when you become alive and not so well, disabled, your loved ones, your disability trustees that you pick, can legally step into your shoes to avoid disability probate court. And then beyond disability is the other D word. When you die, deceased, and you go up to your cloud, now your disability trustees will become your death trustees, and they can have a key to your trust or your treasure chest day number one, because that avoids probate court. So that's the difference right there, folks. Two worlds of difference. So if you desire to avoid what we call the messes and stresses of probate court, if you desire to avoid what we call the economic and emotional headaches of probate court, make sure you create your trust, step one, but most importantly, make sure you engage in step two with an experienced elder law attorney that has a formal trust funding process, because they'll help you get your treasures into your treasure chest. Folks, thanks for joining us here today at elderlawcare.com. Be sure to share this video with others that you love. Be sure to subscribe to our channel, because we will keep you updated on other important elder law matters. If you'd like to learn more, pick up a copy of my book, Patrick Kelleher, Elder Law Attorney, How to Avoid the Four-Headed Monster of Estate Planning and Elder Law, on Amazon, because you will learn a lot. Folks, thanks for joining us here today at elderlawcare.com.